All right, if you're gearing up for the Queensland bar exam, you know that the rules of evidence can be the difference between winning and losing. Today, we are going to zero in on a really critical part of the Uniform Civil Procedure Rules, the UCPR, that's all about how you actually get your evidence in front of a judge. This isn't just dry theory, okay? This is the engine room of a trial. So let's jump right in. So, you've put in the hard yards. You got the statements, the documents, maybe even some recordings. But what's the bridge from having all that stuff to a judge actually hearing it? Well, that bridge is built with the UCPR. And let me tell you, mastering these rules is what transforms a simple pile of facts into a persuasive, winning case. So here's our game plan for the next few minutes. We are going to build your UCPR evidence toolkit piece by piece. We'll kick off with the default rules, then we'll look at just how much power a judge has to manage evidence. After that, we'll tackle special items like photos and videos, see how you can use evidence from totally different cases, and then we'll lock it all down with the key takeaways you'll need for your exam. Okay, first things first. Everything, and I mean everything, starts with the foundation, UCPR Rule 390. This one rule, Rule 390, sets out the two main ways you give evidence, and the path you take, it all depends on how the case got started in the first place. This is a simple distinction, but it is absolutely crucial. You have to get this. If the case began with a claim, the default setting is that your witnesses get in the box and give their evidence orally. But if it started with an application, the evidence is usually given on paper through an affidavit. So just burn this into your memory. Claim is oral, application is affidavit. That's your starting point under Rule 390. But, and this is a huge but, here's the real key for your exam. Rule 390 gives you the defaults, but they are not written in stone. The court always has the power, the discretion, to order something different if it's in the interest of justice. It can say, nope, we're doing affidavits in this claim trial, or I want to hear from this person orally for this application. Never, ever underestimate the power of judicial discretion. And, this quote from Justice Freiberg really pulls back the curtain on how a judge thinks about this. You might think affidavits are quicker and cheaper, right? But he points out that they're often a luxury because preparing them can actually rack up huge costs. So the court is always doing this balancing act between courtroom efficiency and the overall cost when it decides whether to stick with the Rule 390 defaults or not. And that whole idea of judicial discretion is the perfect segue into our second section, because the court isn't just a passive referee. Rules 391 and 392, they give the judge a whole toolkit to actively manage how evidence comes into their courtroom. Now this is a power you really need to appreciate. Under Rule 391, the court can call a witness all by itself, without either party even agreeing to it. I mean, think about that. It's a huge departure from our normal adversarial system where the parties call the shots on evidence. Now, it's a power that's used pretty sparingly, only when it's absolutely vital for justice, but wow, what a reminder of who's really in charge. Next up is Rule 392, and this one has become so important in modern law. This is the rule that opens the door to technology. It lets the court hear from a witness who isn't physically there, using tools like video links or even just the phone. But you can't just ask for a video link because it's convenient. The court needs a good reason. You'll have to show something serious, like the witness is too sick to travel, or the cost of flying them in is just astronomical. Or maybe it's a massive disruption to their profession, or, in some cases, the witness is genuinely afraid to come back to the jurisdiction. So whenever a judge gets an application for remote evidence, they're doing this critical balancing act. On one side, sure, it can save a ton of time and money, especially if the evidence isn't really in dispute. But on the other side, it's way harder to tell if someone's being truthful over a screen. A tough cross-examination can lose its punch, and just trying to show them documents can be a total mess. The ultimate question for the judge when they're looking at a Rule 392 application is always, what is in the interests of justice? And if you want the perfect example of this, just look at the case of Weeks v. Bell. You're not going to believe this. The defendant wanted to give her main evidence from her honeymoon on her iPhone. The court gave that a hard no. It was a massive reminder that a party's personal convenience just doesn't outweigh the other side's basic right to a proper, effective cross-examination. It's really a textbook case for Rule 392. Okay, let's shift gears. We've talked about what people say. What about things? What happens when you want to use a plan or a key photograph or that crucial bit of video footage? Well, the procedure for that is all laid out in Rule 393. Rule 393 sets up a really simple process.
It's designed to avoid surprises and just make things run smoother. If you've got this kind of physical evidence, you must, give the other side a chance to look at it at least 7 days before the trial. The whole point is to get everyone to agree to it being admitted ahead of time, so you don't have to waste court time calling the photographer just to prove they took the photo.
Now, this brings up a classic tactical question, doesn't it? Let's say you have some killer surveillance footage that just completely destroys the other side's story. Can you keep it up your sleeve for that dramatic gotcha moment in cross-examination? Or does Rule 393 force you to show your hand beforehand?
Well, the answer really gets to the heart of modern litigation, which is all about the cards on the table approach. As the court made clear in cases like Conn v. Armaguard, the system is just massively biased in favor of disclosing things before trial. So while you can ask for an exemption from Rule 393, you'd better have a really, really good reason. The days of trial by ambush, they're pretty much over.
Now, let's talk about a super powerful efficiency tool. What if the evidence you need has already been given in a completely different court case? Rule 395 gives you a way to avoid reinventing the wheel, letting you use evidence from other proceedings.
The rule itself is pretty simple. With the court's permission, and that's the key phrase, with leave, you can use evidence from another case. Could be a transcript, could be an affidavit. But look at those words again, with leave of the court. This is never something you can just do automatically. You have to ask. And for your bar exam, this is non-negotiable. You have to know this. The case law, like Wentworth v. Rogers, has basically set up 2 big hurdles for getting leave under Rule 395. The court is almost always going to insist that the old case involved the same parties and that the issues being discussed were basically the same. You can't just go fishing for evidence from some random case with different people. And just as a quick side note to round this out, there's also Rule 395A, which is kind of the flip side. It's the mechanism you use to ask the Queensland court to help you get evidence for a civil case that's happening somewhere else, in another jurisdiction.
Okay, we have covered a lot of ground here, from Rule 390 all the way to Rule 395. So let's bring it all home. Let's pull everything together into the big picture principles you absolutely must have down for your exam. Here it is, your exam cheat sheet. First, remember that Rule 390's defaults, oral for claims, affidavits for applications, are just the beginning. Second, judicial discretion. It's the golden thread that runs through all these rules. It's everywhere. Third, the big test for using that discretion is always the interests of justice. Fourth, your arguments are almost always going to be a balancing act between things like efficiency and fairness, or cost and credibility. And finally, never forget the cards on the table approach, especially when you're dealing with Rule 393 and physical evidence. So, I'll leave you with this question to think about. As a future barrister, which one of these rules do you think offers the biggest tactical advantage in a trial? Is it playing with the defaults in 390, using remote evidence under 392, managing disclosure with 393, or maybe pulling in old evidence with 395? And more importantly, how are you going to use it to win?